Marijuana Prohibition, Part 4. Scott Pearce.
From the end of World War II until today, the federal government has treated marijuana as if it's among the most dangerous drugs on the planet. Until the 1970s, most states patterned their drug laws on the federal models. Let's take a look at a few of the major federal drug laws of the last half-century. The first of these was the Boggs Act of 1951. There was a perception of increased drug abuse, especially among the young. Penalties were quadrupled. Penalties were increased in every offense category. A new rationale was offered to justify the marijuana prohibition. Back in the 30s, the old rationale was that marijuana causes insanity, criminality, and death, at least according to Commissioner Anslinger. The new testimony was marijuana causes passivity. The next big federal anti-drug law was passed in 1956. It was called the Daniel Act. Again, there was a perception of increased drug use. There was a set of nationally broadcast federal hearings on organized crime, the Kefauver hearings, which broke the news that organized crime existed in America and that some of their income came from drugs. The result, an 8-fold increase in the drug penalties that had been quadrupled only 5 years earlier. The states passed Little Boggs and Little Daniel laws to bring their regimes in line with federal law. For example, Virginia had a law from 1958 to 1969 that required a 20-year mandatory minimum sentence without probation or suspended sentences for possession of marijuana or any other drug. Sale of drugs carried a 40-year mandatory minimum. For comparison's sake, at the same time in Virginia, first-degree murder came with a mandatory minimum of only 15 years, and rape had a 10-year mandatory minimum. Now we focus our attention on the Dangerous Substances Act of 1969. Again, there's a public perception of increased drug use, but this time the penalties are lowered rather than raised, and various drugs are placed on schedules based on the drug's medical value and potential for abuse. Schedule 1 had marijuana and psychedelics, such as LSD, which were deemed to have little or no medical use and a high potential for abuse. Schedule 2 included amphetamines and barbiturates, drugs with some medical use and a high potential for abuse. Schedule 3 had codeine and morphine, drugs with a high medical value and a high potential for abuse. Codeine is present in many prescription cough medicines. Schedule 4 included drugs with high medical value and little potential for abuse, such as antibiotics. In 1973, Oregon was the first state to decriminalize minor marijuana possession. They made it a violation rather than a crime, more like a traffic ticket, and the fine was $100. In 1975, the Alaska Supreme Court ruled that cultivating and smoking marijuana at home was legal. 10 other states followed Oregon and decriminalized marijuana during the 1970s. In 1989, Oregon and Washington stiffened the penalties for marijuana possession by raising the fines. In 1990, an amendment to the federal highway funding law required every state to pass a law mandating a 6-month driver's license suspension for any drug offense, even those not related to driving, and it included marijuana possession as a drug offense that would require a 6-month driver's license suspension. Interestingly, police and prosecutors often were found opposing measures to recriminalize marijuana, basically because they considered it to be a waste of time and resources. It is widely estimated that about 90% of all drug arrests in the United States today are related to marijuana. No serious government study ever undertaken has supported marijuana prohibition. The first of these government studies comes from the Indian Hemp Drugs Commission. The British Empire included the territory now known as India and Pakistan. The British decided it was necessary to study the drug culture there in order to decide how best to deal with this large foreign society that they controlled. Their 1894 report was more than 3,000 pages long, and was published in 7 volumes. Their conclusion, quote, "There is no evidence of any weight regarding the mental and moral injury from the moderate use of these drugs. Moderation does not lead to excess in hemp any more than it does in alcohol," close quote. The commission proposed taxing hemp, which the locals called bhang, as in Bangladesh, but the proposal never was enacted, in part because Muslim law and Hindu tradition forbid taxing anything that gives pleasure to the poor. At the end of 1925, the Panama Canal Governor's Committee reported, quote, "There is no evidence that marijuana, as grown here, is a habit-forming drug in the sense of which the term is applied to alcohol, opium, cocaine, etc., or that it has any appreciable deleterious influences on the individual using it," close quote. In 1933, the same committee reported, quote, "Incidents related to marijuana smoking which result in trial by military court are negligible in number when compared with delinquencies resulting from the use of alcoholic drinks, which also could be classed as stimulants and intoxicants," close quote. The American Bureau of Plant Industry was a group of government plant scientists which studied hemp in 1926. They concluded that the hemp plant is one of the prominent weeds in the country, but there is little danger that it will cause a drug habit. One interesting observation, quote, "Though they have ample opportunity, workers in the hemp fields have never become addicts," close quote. Of course, we've already seen how the 1937 Marijuana Tax Act ignored all this evidence and ignored the American Medical Association. The federal marijuana prohibition based its science on that foolish non-physician from Temple University, the guy that testified about the drug's alleged effects on dogs. Decades later, President Nixon appointed a presidential commission on marijuana. Nixon appointed anti-drug ideologues to serve as this committee's chair, executive director, and other positions. This commission weren't even going to allow a formal attorney general and another decriminalization advocate to testify until a newspaper editorial chided it into listening to both sides. The surprise is that many of the other witnesses also spoke out in favor of a more liberal approach to marijuana regulation. For example, the American Bar Association passed a resolution calling for the elimination of all penalties for marijuana possession. The Presidential Commission came back to President Nixon with a recommendation that marijuana be legalized and that all the other drug laws be reconsidered. It also pointed out that the drug laws are enforced with racial bias. Nixon decided that politics was more important than social justice. He ignored the recommendations of his own commission and initiated the war on drugs. We'll get into some of the cynical details of that shortly. The Drug Enforcement Administration studied marijuana under President Reagan from 1986 to 1988. They heard many witnesses and reviewed thousands of pages of documentation. The Drug Enforcement Administration Administrative Law Judge Francis J. Young reached this conclusion, quote, "Nearly all medicines have toxic, potentially lethal effects, but marijuana is not such a substance. Marijuana, in its natural form, is one of the safest active substances known to man. By any measure of rational analysis, marijuana can be safely used within the supervised routine of medical care," close quote. California had a research advisory panel studying marijuana in the late 1980s. It wrote its report in 1990 and concluded that marijuana should be legalized and other drugs decriminalized. Democrat Attorney General John Van de Kamp refused even to publish the report.
This is a production of Nuclear Podcasting. Creative Commons Attribution, Non-Commercial, No Derivatives.